I'm answering the questions that I didn't get to finish in my last interview with Speakeasy. So this is for Hunsinger, Boyd, Odom, and Goss Law Group, LLP. My name is Zach Hunsinger, Hunsinger. And the first question I'm going to answer is, how is time sharing or custody determined in Illinois when a couple is divorcing? What is the best interest of the child standard? And it's key to have that second part in the question regarding the best interest, because that's what the court's going to look at in determining who is going to have custody or time sharing. So just a quick note on language. Illinois is very special, or at least they want to be special, and have decided that we're not going to call things custody or visitation. Instead, we're going to call it allocation of significant decision-making, primary decision-making responsibility, and award majority of parenting time. So custody is parenting time, decision-making. Visitation is the parent who didn't get those things. So you would be awarded majority of parenting time when you're not with that child. During that awarded parenting time, the other parent is presumed to be with that child, and therefore it's visitation. So you may hear me say those things for kind of just general understanding and ease. I tend to say custody and visitation. It's shorter to say at the very least, but it's also a little, I think, clearer, because that's what most of us tend to think of when we use those terms. So what is the best interest of the child? It's an abstract concept that the legislators have attempted to legislate into a statute. So they did put this, they put 15 factors into the statute that judges are supposed to consider. And if you're a bit of a statute geek, you're welcome to look this up at 750 ILCS 5/602.5. For everybody else who isn't a geek, I'll go ahead and just show you some of what those factors are that the court is supposed to look at when determining the child's best interests. And they start off with the wishes of the child's adjustment to homeschool and community, mental and physical aspects, wishes of the parents, child's needs, the level of each parent's participation in prior significant decision making, and then kind of the catch-all of any other factors that the court expressly finds to be relevant. So it's just making sure they're not pigeonholed into those 14 other categories. The reality, though, is I guess sometimes attorneys might put up a table of, here's the 15 standards, judge, and here's how our client meets those 15 standards and therefore award custody to our client. Usually it's much more informally discussed than something like a structured table or something along those lines. Instead, it ends up kind of resting on, well, what parent was primarily performing the caretaking before the divorce? And therefore, we'll assume that the kid or that parent will continue performing those day-to-day caring activities for the child. So that's whether the judges admit it or not. That's how the courts are going to begin with their analysis on how to determine, well, what parent's going to be awarded custody. Once you know who that person is, then it's up to either reinforce that if you're representing the parent who primarily is a caretaker, or attack that. And the way you do is you would look at some other, you'd bring to light some other factors that are in that parent's benefit. Like, okay, yeah, let's just say, for example, dad wasn't the primary caretaker before, but now dad has moved to a school district with a top tier school. The kid already has friends from summer camp that live in that neighborhood, so then they'd be able to hang out with those friends more often. There's also extended family nearby, so the cousins that the children were really close to will be even closer. I don't know, maybe something, maybe they can hire a really awesome nanny or something. So those would be factors then that would come to light to kind of fight off who was the primary caretaker before. Whereas the other attorney would be saying, no, mom was always the caretaker. Mom can maybe not provide the same top tier school, but an adequate school, because that's what the school the kids would have gone to anyways. Previously, they would have, if the marriage had remained intact, the lifestyle of that family would have still been, they would have gone to this school. So why take them out of that school and put them somewhere else? And also, mom here has attempted to facilitate a loving and healthy relationship with the other parent as well. So, and dad, in contrast, has not been showing any willingness or ability to facilitate and encourage a close and continuing relationship between the other parent and the child. So you're going to hear those two things, and like they both sound really good. So how are we going to decide what is in the best interest of the child? Well, that's going to be up to the judge to look at those factors that the mom's attorney laid out and those factors that the dad's attorney laid out, and then say, you know what, here it is. This is what's going to happen. Too bad. If you don't like it, but that's what the ruling is. That's why we have trials and to make those determinations, because they're not easy. I mean, if they were easy, they wouldn't go to. You wouldn't need an impartial, objective judge to make a ruling, because you would have sorted it out amongst yourselves before it got to that level. So I guess to summarize between, well, not between, but how is custody determined when a couple is divorcing based off of the best interest of the child standard? They look at those 15 factors, kind of starting at, well, who was the primary caretaker, and if one parent doesn't like how that may turn out, well, what's that parent going to do differently than historically that would put the children in a better position according to those 15 factors that the statute has lays out.